figured.
This Thursday, December 2019 hearing officer meeting is called to order. I am Los Angeles County staff member Gina Natoli. I will be the hearing officer on all agenda items today. I'd like to go through a few administrative items first. Please turn off or silence all electronic communication devices. There are agendas of today's proceedings available in the back of the room if you would like to follow along with our proceedings today. There are established time limits for testimony on hearing officer agenda items. Petitioners have up to 10 minutes for their initial presentation and up to 5 minutes for a rebuttal. Respondents have up to 10 minutes. All others will have 2 minutes each, and there is no ceding of time. Anyone wishing to testify today on any agenda item, and that includes the public comment period, must fill out a speaker card and submit that to staff. Thank you very much. There is an audio and video recording being made of today's cases, and the recording will be available on Department of Consumer and Business Affairs website within, I think it's about three business days. I assume there may be a couple of people here in the audience today who need translation services, and for items where translation service is requested, the time limits may be adjusted. And finally, let me announce that the building is scheduled, we are scheduled to have a building fire drill today at 11:30. If we are still here at 11:30, the fire alarm will sound and we will have to leave the building. I will lead us to this building's designated gathering location, which is just to the south of us in the Court of Flags. We would need to remain there until we are given the all clear to return to the building. Then we would come back and resume the hearings and pick up right where we left off. I do not anticipate that we will still be here at 11:30, but in case we are, just so you know, that's what's happening. And frankly, I will be curious to see if we actually find out in this room if the fire drill has officially begun, because I'm not sure this room gets that. I get a text though, and an email, so I will have that on my iPad here. The general procedure for today's agenda items is as follows. First, staff makes a brief presentation, then the petitioner will speak, then the respondent speaks, and then I will ask members of the public to speak. If necessary after that, I will hear rebuttals from the petitioner. Final decisions made by hearing officers on landlord petitions which do not assess an administrative penalty, and final decisions on all tenant petitions are final and are not subject to further action at the county. So if you intend to testify today on any agenda item, and that includes the public comment period, I would ask that you stand at this time to be sworn in. And I see we have 2 people coming in the back. If I could ask you to go ahead and be sworn in, and then you can fill out your speaker cards in a few minutes. You can stand where you are to be sworn in, that's fine. So please, if you think you will be testifying today, even if you're not sure, but if you think you will be testifying, please stand to be sworn in. We have 2 gentlemen here who are still seated. Are you planning to testify today? If you are planning to testify today, please stand. It does not, being sworn in does not obligate you to speak. All right, please raise your right hand. Do each of you swear or affirm that you promise to tell the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. I have speaker cards for each item today, therefore I will be taking the agenda items in order. We're moving on to part 2, public hearings, starting with item 2. Also, let me say that several items, the request from Department of Consumer and Business Affairs today is to continue these items. So that's continue. They're going to be requesting that items 2, 3, 4, and 6 be continued. That means I will not be making a decision on those items today. Individuals who are here to testify on those items, I will open the public hearing for those items, and you will be able to speak today. I will take your testimony, but I will not be making a decision on those items today. Ms. Lewis, please proceed with item 2.
I'm asking to present items 2 and 3 together. They are neighbors.
That's fine. Please go ahead.
Thank you. So items 2 and 3 are for case numbers RSQ 1912982, which is DeAndrea Simmons versus Metro Investment Group, and case number RSQ 1913512, which is William Williams versus Metro Investment Group. Both items are petitions for noncompliance to request reductions in rent in accordance with the allowable limit as established by the ordinance, interim rent stabilization ordinance number 2018-0045. The petitioner, DeAndrea Simmons, she formerly resided at the property, which was at 2127.5 Raymond Avenue, Altadena, California, 91101. William Williams is still residing at the property at 2119.5 Raymond Avenue, Altadena, California, 91101. At this time, we're requesting, DCBA is requesting additional time for review and analysis of the supporting documents provided by both the petitioners and the respondents. And we're requesting that the hearing is continued to January 30th, 2020 for both cases. But we also are asking that you open up the item to allow for testimony from either the petitioners or the respondents.
Thank you very much. Let's start with item 2. I'm opening the public hearing for item 2, case RSQ 1912982. And do you have anything else to add, or can I just call the speakers?
I have nothing else to add.
Thank you. Then I'm calling for item 2, DeAndrea Simmons, please. Please come on down. We have the table here. There are a couple of chairs at the table. Doesn't matter which one you sit in. Take a seat, either one. There's a timer on the table in front of you, and it's set to start at 10 minutes. When your time to speak starts, the green light comes on. When you have 30 seconds left, the yellow light comes on. So when you see the yellow light, if you're still speaking, just try and ramp up your comments. And the red light means your time has expired. Use as much time as you need or as little time as you need. That's completely up to you. All I ask is that you just state your name for the record before you begin. Please go ahead, ma'am.
My name is DeAndrea Simmons. I'm a former resident of 2127.5 Raymond Avenue, Altadena, California, 91001. I'm here today due to the action of Metro Investment Group has sent us a 60-day notice to vacate. That was actually October 10, 2019. He wanted us out by December 10, 2019 without a reason or cause, and also a rent increase over 10% that I have been paying since I've been there. Due to the situation of it, I am a single parent. I have 2 kids, and dealing with the situation, it caused me to leave the property on November 13, 2019 to find other residents. I didn't want to leave my family in limbo, dealing with everything. I did file a petition, yes, but I want to make sure that he's in compliance, and if he owes me any overage dealing with the situation that he's caused.
Ms. Simmons, how much were you paying on September 11th, 2018?
$11.50.
And how much were you told that your rent would be increased to, or were you given a rent increase?
Yes, I got a rent increase, and they increased it up to $12.65.
Thank you. And you did receive a 60-day notice of the increase?
Yes. No, I received a 60-day notice to vacate. I received the increase. The rent went up in June 6, 2018 or 19, one of them.
June 6th this year?
Yes.
Okay. And how many months did you pay that increase?
From the duration they start the increase, which was probably June 1st of this year, all the way to current.
Until you left the premises?
Correct.
And when did you leave?
I left November 13, 2019.
So you paid June, July, August, September, October. Did you pay November?
No, I didn't.
So 5 months?
Yes.
All right. And that's 5 months at the higher level?
Correct.
All right. Thank you very much. I don't have any further questions for you at the time because I don't have the paperwork from DCBA to evaluate the rest of the case. So thank you for coming down today and giving me this information. So I'm not making a decision today. If you choose to come back on the 30th of January, that's completely up to you. It's not essential that you be here because I have your testimony, and I've taken that information from you. If there's a decision made that the landlord exceeded the rent stabilization ordinance amounts, DCBA staff would make sure that you are refunded the money.
Okay, thank you very much.
Thank you, Ms. Simmons. And I just received a speaker card here for Anthony Noward from Metro Investments Group. I will call this individual after I hear from the speaker for item 3. Because this individual, you were responding to both items 2 and 3. So let me call the speaker for item 3 first. All right. At this time, I am opening the public hearing for item 3, case RSQ 19-13512. And I call William Williams. Morning, Mr. Williams. Either seat, that's up to you. Whenever you're ready, please begin, sir.
Ready?
Yes, sir. Just state your name for the record.
William Williams.
Thank you, sir. Please go ahead.
Well, I'm here on behalf of a 60-day vacate notice and a 10% increase. It was a shock to me because I'm a single father, and before moving into the property, I was homeless and I was on Union Station. So after that program ended, I went to market rent, which was $12.50. So shortly after that, maybe 5 months later, I got another increase, which was 10%. And so from June 1st to November, I paid my rent, the increase, the 10% increase. So I paid all the way up until November. I even paid this month rent. So he corrected my rent. So he $588 he deducted. So my rent this month was $759.
That was $759 for December.
for December.
The overage that you paid from June through November
Remember,
has already been refunded to you.
refunded. It wasn't refunded to me. It was taken off of the rent. Yeah, well, refunded. Yes.
Right, so did the landlord keep 3% of the 10% increase?
Yes,
And
he
give you
did.
back 3%?
Yes.
Give you back 7% and kept the 3% increase?
Yes, my original rent after the program ended, it was $12.50. So now it's $12.87. So that 3% increase is still in place.
And the increase that you paid for 6 months, what was the increase? How much were you required to pay for those 6 months per month?
I think it was $175.
It was an additional $175. So it went from 12.
On top of the $250.
So it went from $12.50 to $14.20.
$13.75.
$13.75.
Yes.
So that's $125.
$125. Yeah.
Right. All right, thank you, Mr. Williams. I don't have any other questions for you at this time. Again, I can't make a decision today because I don't have all the paperwork in front of me.
Understandable.
You are welcome to come back on the 30th of January or not. I have your testimony, and that decision will be completely up to you, sir.
Thank you.
You're welcome. Thank you. I'm going to call Anthony Noward. Good morning, sir. Again, just if you could state your name for the record before you begin, and then you may begin.
Anthony Nawait, representing Metro Investments Group, Inc.
And what would you like to add to the testimony that's been given today, sir?
The rent increases that we did, and is because we really were not aware of the ordinance that county had. So we are under the impression that it was going to be in effect January of this coming January. So we give the rent increases with 60-day notices, which was the applicable codes at the time. However, when we got contacted by Housing Department, County of LA Housing Department, we went back and gave the credits to both of the tenants, both to Mr. William and Ms. Simmons. Mr. Williams' credit was given to him as a one lump sum credit for month of December. We didn't even do it as 6 months as it was suggested by Housing Department. We just give it all as one lump sum. The notices that was given for Mr. Williams and both Ms. Deandria Simmons were given to them on April 1st of this year to be in effect on June 1st of this year. So we collected that additional amount from June for Mr. Williams from June to November, but the entire amount was deducted from his December rent. So Mr. Williams got a credit of $528 from us, deducted from his rent in the month of December. However, in Ms. Simmons is a little different because she abandoned the place and she didn't pay her rent for the month of November. She was served with 3-day notices. She didn't fulfill it. She abandoned the place. Contractually, she not that didn't pay us month of November rent. She also would be responsible for lack of notice and 1 additional month of rent. However, the amount of the increase that or deduction she should have get was entirely deducted from her November rent, entirely. So we calculated from June to October how much was the overpayment. We applied it to her November rent. However, she did not pay her November rent either, and she has left the place. She abandoned the unit. And then we obviously made a security deposit itemization form, which was certified mail to her, and we calculated all the damages and stuff. So by applying the rent deduction that we're supposed to, she even didn't pay that. She hasn't paid us anything for November, and she just left.
All right, Mr. Noaid, so the security deposit items are outside of my authority. The rent issue, which months did Ms. Simmons pay? Did she pay? First of all, when did the rent increase go into effect?
June. It went in effect in June. By the way, I have some documents. If you would like, I can provide them. I have copies, but I have some documents in here.
What I would prefer is that you make sure that those go to the Department of Consumer and Business Affairs staff.
Yes.
I will see those before the next hearing, the continued hearing date. What I would like to do today is get testimony from you that may not be in the paperwork.
Sure.
So from June through October.
Yes. So her rent in month of before the increase was $1,150. We raised the rent to $1,265. So there was an addition. We overcharged $81 per month. We actually rounded up to the bigger number. It should have been $80.50, but we rounded up to the higher number in their favor. So in 5 months, she would have get $405 credit. That per the ordinance that they told us to be refunded to them in 6 months, but we went voluntarily told them deducted from your rent in month of November. That was deducted from the rent for month of November, so that brought the rent for month of November down to, I can tell you, Your Honor, for November, the rent came down to $779 after applying the appropriate credits.
So basically returning the 7%
7% increase.
above
Yes.
for each month.
Yes.
All right. Okay, Mr. Noaid, I do not have any other questions for you at this time. And as I mentioned to Mr. Williams and Ms. Simmons, you are welcome to come back on the 30th. I am not making a decision today because I do not have all the documentation in front of me from DCBA staff. But I also have your testimony that I will be using to assist me in making my decision, as well as testimony from Mr. Williams and Ms. Simmons. I don't have any further questions for you at this time. So I do appreciate you being down here and answering questions. It's always helpful to see the folks who are involved.
No problem. Anytime.
Thank you, Mr. Noaid. So, Ms. Lewis, I don't have any other questions for you at this time. Do you have anything to add to the testimony that's been given this morning?
Not at this time.
Right. Then to provide sufficient time for review and analysis of submitted documentation, item 2, case RSQ 19-12982, and item 3, case RSQ 19-13512 are continued to 30 January 2020. All right, next we have item 4, which is case RSQ 19-13263. Ms. Lewis, please proceed.
Thank you. The item is a petition for noncompliance, and it's Juan Santos versus Eptaham Aji. It is to request a reduction in rent in accordance with the allowable limit as established by the Interim Rent Stabilization Ordinance 2018-0045. The petitioner resides at the property located at 3955 Dozier Street, Los Angeles, California, 90063. The Department of Consumer and Business Affairs is requesting additional time for review and analysis of the supporting documents provided by the petitioner and the respondent. We're requesting a continuance of the case to January 30th, 2020.
Thank you very much. I don't have any questions for you at this time. I'm going to open the public hearing for this item and I call Mr. Ibrahim Agai. I hope I said that correctly. Good morning, sir.
I already with Mrs. Lewis, we settled the payment, no problem. But
Mr. Guy, I just need you to, before you begin speaking, if you could just state your name for the record.
my name is Ibrahim Abi Agai.
Thank you, sir.
I apologize.
Please go ahead. Go ahead, sir.
Yes, I already about the rent. She settled it between me and the tenant, no problem. But they are under the eviction because they have so many violations in the lease that they did, so many violations, starting from tampering the unit, making a separate room inside every room, using in place of 2 parking space, they use all the other parking seats. That's for eviction. I understand that's not your department. But the only thing here, Mrs. Lewis, she settled the payment for the monthly for returning whatever I have to return to them. I purchased this property in end of 2015 after they diagnosed cancer in my gallbladder. And when I came out of the hospital, I had a plan to have something for, if I'm not around, for my family and my wife, my children. And when I rent one unit to these people, unfortunately, they came out very bad tenant. They destroyed the property. And the biggest problem is they are fighting even physically with all the neighbors in the block. That's why I got so many letters from the other neighbors that they send it to me through a lawyer. Seven neighbors in the block, they are hiring a lawyer to come after me because I am the property owner to evict them. They say if you don't evict them, all the neighbors, they go after me. Anyway, regarding the payment of the rent, she settled it between me and them, and I agree with that until I evict them from there. That's all.
Thank you, Mr. Gahi. So when did you start charging the higher rent?
When I broker bought this property for me, because it was built in 1991, he said because it's built after 1978, it's not under rent control. It was not under rent control. And when I rent them 2016 and 2017, the rent become from 1,500 to 1,575. And because it was not 5%, I increased. But the next year, they told me because it's not under rent control to increase 10%. But Ms. Lewis says it have to be only 3%. We calculate it, and I have to give some refund to them before they leave. I'm ready to pay one shot everything to them if they want to leave, or make it for 6 months, 6 payment.
So my question to you is, on September 11th, 2018, how much were you charging Mr. Santos?
$1,575.
And when was the first time?
Sorry, he mentioned to Mrs. Lewis that 1,500, but 1,500 was first way they moved in. It was 1,575 on 2018.
All right. And then when was the first time after September 11th, 2018, that you raised the rent?
For the year 2019.
So starting in January 2019?
No. Exactly from the month that they moved in, I believe it was October 2018 I gave them the 60-day notice for 2019.
Okay, was Mr. Santos living in this unit on September 11th, 2018?
He was living there, yes.
And he was paying $1,575 a month for
Yes, Your
rent?
Honor.
All right.
Yes.
So when was the first time after that date that you raised his rent?
The year after that, for 2017. After 2018, for 2019.
And you're saying that started in October 2019?
Yes.
So September 2019, Mr. Santos was paying $1,575. And then for October 2019, you raised it 10%?
Yes. I show all the bank statement to Miss Lewis, and she saw them.
And how many months did Mr. Santos pay that 10% increase?
Until the next increase that was for 2019, that means 2019 for 2020, I give him the notice.
So
But it's canceled already.
I understand that, and thank you for that information. So you increased it 15%.
10%.
I'm sorry, yes, 10%. You increased it 10%, which was $158?
Yes.
Right, so the increase was $158. How many months has Mr. Santos paid, or did Mr. Santos pay that extra $158? October, November?
For the whole 12 months. For 12 months.
But if you raised the rent in October 2019, this is just December 2019.
Yes.
So what he's actually paid you.
No, for November, he paid the 10%. She already deducted them. For this month, he paid the new increase that 1,400 something come up.
Okay.
I have the paper here.
All right, so did he pay the full $158? Did he pay that 10% in October and November, or just November?
October and November.
Okay.
But it's already will be returned to him.
I understand that, sir, but if I don't understand the facts, for me to make my findings on a case, I can't make my findings unless I have the facts, and I know how many months, because I have to say, yes, either this tenant gets so much money back because the tenant paid 10% for 2 months or 10% for 3 months. I just have to know the facts so I can put it all down on my paperwork. And I'm not taking any paperwork from you today because I don't have the documentation for the case. Ms. Lewis hasn't had the opportunity to get through all of the documentation yet. When she does, before the January 30th continuance date, I will have all of that information in front of me for me to be able to make a decision. So I'm not taking paperwork now, I'm just taking your testimony today. Just make sure that Ms. Lewis has all of that information so it goes into the report that I will get.
Okay.
All right, thank you, Mr. Agahi. I do not have any other questions for you today, and I appreciate you coming down. As I mentioned to the other individuals who are here today, I'm going to continue the hearing to the 30th of January. You are welcome to come back on the 30th, but it's not mandatory that you come back on the 30th because I've received testimony from you today. So again, that's going to be completely up to you if you'd like to come back on the 30th.
Absolutely. But right now, in this moment, they are paying the lowest rent for this month. I mentioned to you. That's why I was going to show you the paper.
Yes, and I've written that down, and I appreciate it. Thank you very much, Mr. Agahi.
Thank you, Your Honor.
You're welcome. And do you have anything to add to this case, Ms. Lewis?
Yes, so we have been working with both the landlord and the tenant in this case on their documentation. There's some additional documents that we need from the respondent, and I'm asking, he has them with him today, I'm asking that he provides them to us so that we can go ahead and double check all of the information that's been provided, because we were able to work with him to calculate out an overpayment, but there's some discrepancies around that.
All right, thank you very much. Thank you, Mr. Agahi. I don't need anything else from you today. As I'm not making a decision this morning, to provide sufficient time for review and analysis of submitted documentation, item 4, case RSQ 19-13263, is continued to 30 January 2020. I have a speaker card here for item 6, but I don't see an individual here for item 6. Aren't you, Mr. Howling, for item 5? All right, because I was going to take it out of order since this item 6 is going to be continued, but if Mr. I'm sorry, Ms. Fernandini? Oh, he filled it out just in case he needed to speak. All right, well then I won't take the items out of order because the individual for item 6 is not here. We're moving on then to item 5. This is case RSQ 19-03285. Ms. Lewis, please proceed.
Thank you. So the item you mentioned is for an interim rent stabilization ordinance petition for relief from moratorium. The petitioner is LLJ Stratford Rowland Heights LLC, which is a landlord, and the respondents are the tenants located at 1940 Fullerton Road, units 1 through 126, Rowland Heights, California, 91748. The petition was filed with us on March 27, 2019. The petitioner is requesting to pass through costs associated with the completion of capital improvement projects at the property as allowable under the interim rent stabilization ordinance number 2018-0045. The property is located in the unincorporated area of Rowland Heights, is a residential dwelling on a property with 2 or more units, and was built in 1974. The petitioner returned the proof of service to DCBA on April 18, 2019, and DCBA mailed the original notice of hearing on May 3, 2019. I should mention since then the case has been continued, and that's how we're at this state. The following capital improvements were reported by the petitioner and substantiated by DCBA. Plumbing, a carport reconstruction, and removal and replacement of asphalt in the parking lot. DCBA received the following paid invoices from the petitioner. We received paid invoice from Phil Brothers Construction for $1,133,100. Another one from Imperial Contracting for $575,754.15. And the last one from NPG Asphalt for $151,389. That totals to a little bit more than $1.8 million. As I already stated, these are related to the plumbing, the carport reconstruction, and the removal and replacement of parking lot asphalt. Key issues. So 70 of the 126 rental units on the property were rented out prior to the completion of the capital improvement project, meaning they'd be affected by any recommendations in this petition. Also, the petitioner is requesting a monthly pass-through of 5% in excess of the allowable limit, currently 3% for each affected unit. What I want to say regarding the pass-through of 5% is that's specifically related to the capital improvement pass-through. That's not related to them asking for a maintenance of net operating income adjustment. And where allowable, the petitioner has already issued rent increases to affected tenants. The interim rent stabilization ordinance and implementing rules and regulation allow for review of capital improvements and their costs to determine whether and to what extent the capital improvement was reasonable. To determine the monthly pass-through of the related expenses, the total cost should be divided by the number of affected units and should be amortized over the reasonable life of the improvement. In most cases, the reasonable life should be no less than 5 years, as determined by the hearing officer. And the cost of the capital improvements may be passed on to affected tenants as a rent increase divided by the number of affected units and amortized over the useful life of the improvement. And I apologize, it's not a rent increase. It's just as an increase to their monthly obligations. Okay, so here we performed an analysis on the reported capital improvements, reported and substantiated. So we start here with the total amount paid, meaning for all of the project that the petitioner paid. So again, they had plumbing, a carport reconstruction, and asphalt removal and replacement. In the next column, we are looking at the total allowed to be passed through. We were able to determine that based on how many tenants would be affected. So for the remaining 56 tenants at the unit, we did not want to allow the entire, for the affected 70 tenants at the unit, we did not want to allow the total amount paid to be fully passed on to only be split by 70 tenants. And that's because the remaining 56 tenants have rents that are not controlled by vacancy. They're vacancy decontrolled. And so the landlord has the ability to set rents at the market rate with no restrictions from the interim rent stabilization ordinance. So like I said, the next thing we did was calculated out the total pass-through amount per unit. And based on the 70 units, we determined that plumbing would have about almost $9,000 per unit. The carport reconstruction would be about $4,500 per unit, and the asphalt and removal would be about $1,200 per unit. And I want to make sure to say that that's for about 55% of the units. Continuing from our first part of the chart, we looked again at the total pass-through per unit, just like the numbers I just mentioned, and we are recommending an amortization period based on the work performed of 120 months for each of these. Split out in that total pass-through per unit divided out by 120 months, we were able to determine for the plumbing that would be about $74.19. For carport reconstruction, $37.70, and for the asphalt removal and replacement, $9.91. In total, that would be $121.80. So here's just the breakdown in the formula again of how we arrived at this. We looked at the total applicable costs, meaning about 55% of those costs divided by the affected units. And then we divided that out by the amortization period to get the monthly pass-through. Again, it's $121.80. And if that's at 50% of a pass-through, that would be about $60.90. At this time, staff is recommending approval of the interim rent stabilization ordinance petition for relief from moratorium, case number RSQ 1903285. There are some recommendations that we have for that approval as well. The first being that only 50% of the capital improvement costs may be passed through to the affected tenants for a maximum of $60.90 at any given time. One thing that I want to say about that is that we are only asking that 50% is passed through to the tenants, as both the tenant and the landlords it's recommended that they share in the cost of the improvements and both benefit from the capital improvement work that was done at the property. We are also asking that the capital improvement pass-through does not commence until the affected tenants are served a proper written notice. Additionally, the pass-through amount of $60.90 shall not exceed 120 months. Again, that's the amortization period at 50%. It shall be listed as a separate line item and not deemed as rent. It's important for us to distinguish that because we want to make sure that if the landlord is taking any allowable rent increases, it's not on the base rent plus the pass-through if approved. The pass-through should also indicate an expiration date. And we also wanted to point out that the petitioner may increase rents by the allowable limit where allowed by the interim rent stabilization ordinance and the permanent ordinance, and capital improvement, again, should not be calculated into that rent increase. The combined allowable increase in capital improvement pass-through shall not exceed 10% per year. So that may result in the petitioner not receiving the entire allowable pass-through of $60.90 in certain years, depending on what the allowable increase is determined to be. And only 70 of the affected tenants may be charged for the pass-through. The remaining 56 shall not receive a capital pass-through on top of their actual rent that's charged. And we say this because the landlord has the ability to set rents at the rate that they would like to set them at where the vacancies occur, and whatever that rate is, it should include any costs that would have been related to the pass-through. It does not have to be separated out, but it should have already accounted for that. Thank you.
Thank you. So getting to the questions on my memo, there was no net operating income calculation for this request, this petition. Is that because these are considered all pass-through costs and it's not just, gosh, I want to raise the rent, it's I need to because I need to increase my income because I paid out a lot of money. I did capital improvements.
That's correct. So these would all be deemed as capital improvements and not necessarily maintenance and repairs. The big difference in that is that there's some type of replacement that's happening or something that the tenant hadn't previously benefited from. And for this was new work that had been performed at the property, so there was no maintenance and repairs that had occurred.
All right. Well, let me jump down to that then, because you talked about and recommend that only 50% of the capital improvement costs be allowed to pass through. You say that both the tenant and the landlord benefit from the improvement. Could you explain how in what way both would benefit from the improvement?
Yes, I'll actually have Dana Pratt come up and explain.
Thank you. Ms. Pratt?
Thank you. So DCBA is recommending only a 50% pass-through because for the tenants, they are benefiting from the capital improvements. However, we believe that property owners also benefit in terms at any time any improvements are made at the property, they're receiving an equity share for those particular improvements. It's also something that is regularly done in other jurisdictions in terms of not having a 100% pass through for all improvements.
All right, thank you. And then I don't know if you want to stay at the podium for the other portion of that or sure. Turn it back over to very capable Ms. Lewis. The staff report states that only 70 of the affected tenants may be charged the pass-through, and the remaining 56, don't say units, shall not receive a capital pass-through. But then it states that the rental rate for new vacancies should account for the capital pass-through, and the pass-through may not be charged in addition to the listed rent. I'm not quite sure what that means, because For the 70, they get a line item that says rent, and then they get a line item that says capital improvement to be paid off by 2029. Will end in 2029, and so this $60.90 or $121.80 will end at this period. But the 56 just get a rent increase that may include $121.80, and it goes on forever. So I'm not quite sure.
I can clarify that. Okay, so for the 56 tenants that we're not recommending the pass-through for, all of those tenancies began after those improvements were already completed. And so when Ms. Lewis mentioned the vacancy decontrol, at that point when those tenancies began, the landlord had the opportunity to charge market rate. There was no limit as to what they could have charged at the beginning of the tenancy. They are now limited to that 3% or whatever it should be in future years. And so we don't recommend a pass-through on those units because while they may be benefiting from the improvements that occurred, they had already taken place and had been already completed at the time that they moved in. So any rent charged, we believe, should have accounted for those fees or those costs.
Even though it may be that those folks will be paying that increase for the rest of their tenancy, which could exceed 10 years.
We're not recommending that they be charged the additional 121 or the 60. It's just that whatever they were charged should have accounted for any operational costs, is what we're saying. So they're only getting on top of whatever base rent they, at the time that their tenancies began, they will get the 3% or whatever that allowable increase is in the future, and not an additional line item.
I understand, but in this instance, the landlord I'll say gets away with not having to put in a separate line item. It's just considered rent, and I understand that supposedly that's figured into what you're going to charge a new tenant, but hypothetically, you could add, as a landlord, I could add the $121.80 to those 56 units and just have it go on forever. It seems to me that, and I am just calling it rent.
Okay, well, it's not, it's whatever rent they're charged at the beginning of their tenancy, and that could have included that, but again, we're not saying that they put in $121. I don't know what calculation they did. So they made their own calculations as to what they should reasonably charge whenever tenancies occur based on what the market will bear typically. And that's commonly done in most jurisdictions, that when there is a vacancy, that they will increase the rent, because if it were controlled, then they will typically raise it to market. So every tenant at some point is going to be paying drastically different rates based on that reason.
Yes, very much so.
Yeah.
All right, thank you. And then the last question I had dealt with the expenses. My understanding is that when we consider expenses, that those are from the base year compared to the petition year, and I'm wondering if that also applies to these capital improvement costs, because when I looked at the additional materials or supplemental materials for this item, one of the invoices from NPG Asphalt has a service date as 22 December 2017. So I'm wondering if should that actually be counted in this?
It should, because the base year begins September 2017.
I thought the base year began September 2018.
That's the petition year, or depending on when the petition was filed. But the base year begins from September 2017 and it goes through August 2018.
Wasn't the ordinance effective 2018?
Correct. And what we look at is the 12 months immediately prior to the ordinance going into effect.
So this is the issue we had way at the beginning when we were starting to do these. there were some expenses from January and February and then nothing else, because here it was February 2018, and if we go back a full year, okay.
Correct, yeah.
All right.
Enough time hadn't lapsed to compare the base year and the petition year, just based on the timing of when those petitions were filed.
All right, thank you. All right, I don't have any other questions for you at this time. I'm going to open the public hearing. And I have one speaker card for this item. I'm calling Mark Halling. Thank you, sir, and thank you for your patience. Please have a seat, and if you could just state your name for the record before you begin.
Yes, I'm Mark Halling from Stratford Partners, representing LLJ Stratford Rowland Heights, LLC. I appreciate the opportunity to be here. It's been a long road, as was mentioned. We filed our petition in March. I'd like to thank Ms. Lewis and the DCBA staff for their persistence and diligence throughout. I mean, I feel like our case is probably more intricate and complicated than many of the other ones, and really appreciate her patience through the process to get us to this point. I don't feel like I need to rehash the circumstances. We submitted our kind of written report back in May, and nearly all of it was adequately covered in the DCBA memo. I'd say we approve of the findings and the recommendation. The only question I had, and we just touched on it, was the 50% calculation at the end. I understand the logic better as expressed. I do wonder why it's 50 and not 60-40 or 55-45 or some other calculation. And I guess maybe some of what is going through this process is setting precedents for the future that would sort of better govern how that is. But in general, I sort of approve of the findings and appreciate what they've done, and I'm happy to answer any questions or provide further clarification on sort of how we got to this point and where we move from here.
Thank you, Mr. Halling. I don't have any questions for you. These seem like very straightforward capital improvements to the properties, so I didn't have any questions about those. I will ask staff, though. I believe you said that the 50% is something that other jurisdictions do. There's precedent that this is what happens in other jurisdictions, and so somehow, somewhere along the way, people feel that both the tenant and the landlord benefit equally from a capital improvement. Is that why it's 50-50 instead of 60-40?
That's correct.
Yeah, I believe in San Francisco, it's up to a certain point, it's 100% can get passed through to tenants, and then above that level, it triggers to being 50-50. I don't know what that threshold is. I'd say one thing through this whole process is, as an owner and a landlord, just appreciate better clarification on what the rules are. We submitted our petition before even the initial memo was prepared, kind of outlining how this would work. And I would just encourage everyone involved as we move forward to add better clarification so we kind of know when we are identifying investment opportunities, anticipating capital projects, just a richer understanding of how it would work, what the potential may be. It just helps, I think, everything work when there's good transparency and understanding. And as this becomes from interim to more permanent, hopefully some more of that structure will be put in place and there'll be clearer expectations all around.
I'm sure it is an iterative process. And just to comment, I don't know that anything that happens in San Francisco can be used as a benchmark for anywhere else, almost anywhere else in the country. Maybe New York City, but that's probably about it. So good luck, San Francisco. Yeah.
Understood. The only question I have, and this may be more sort of after the fact, is the pass-through able to take effect immediately, or is that something that we have to wait for the current lease term to expire? Again, more of an implementation question, and maybe not the right forum for that question. But yes, I don't know if you have 6 months left on your lease term. Can we come in immediately and do that, or how does that process work?
That's some information that will be provided to you in your findings from the hearing officer if approved.
I have up to 20 days after making a decision on a project to issue my findings. Typically, the decision goes into effect at the beginning of the next rental period. So if I finish by the end of this year, then if there's adequate time, it could be implemented starting in January.
Understood.
So it's not, we don't have a 60-day, I don't have a 60-day notice period before you can do anything about it. The state may, I don't know about that. That's something the experts at Department of Consumer and Business Affairs can tell you about, quote, rent increases, unquote, or capital improvement pass-through increases if there is a mandatory notice period before you can implement it. But I don't say you have to wait 6 months to do it.
Understood.
All right, Ms. Lewis or Ms. Pratt, do you have anything to add to the testimony that's been given today?
We do not. Thank you.
All right, let me go through my discussion on this item. The interim rent stabilization ordinance states that petitioner has the burden to prove by a preponderance of the evidence that because of implementation of the ordinance, before I go on, I should ask County Council if you've heard anything today that causes you any concern about, or that you feel that you need to add to the information given to me so that I may make a decision today.
I have not, Madam Hearing Officer. I think the analysis is quite thorough, step by step, and nothing concerns me regarding the analysis. Thank you, though.
Very good. Thank you, Mr. Trent. The interim rent stabilization ordinance states the petitioner has the burden to prove by a preponderance of the evidence that because of implementation of the ordinance, the landlord is unable to obtain a fair and reasonable return. This is a pass-through request, but the concept is the same. The documentation submitted by the petitioner, as reviewed by DCBA staff, substantiates that the petitioner is entitled to pass-through costs. The documentation substantiates by a preponderance of the evidence that because of the ordinance, the landlord would be unable to obtain a fair and reasonable return as defined by the ordinance. I am closing the public hearing. Given the evidence presented, I affirm the petition for relief from moratorium for case RSQ 19-03285. Petitioner may increase rent of increased cost to the 70 affected units as allowed by the ordinance up to the 3%, with annual increases of 3% without consulting DCBA, and to recover the costs of capital improvements conducted in 2017 and 2018 at the $60.90 per unit per month fee, not to exceed 120-month period. While the petitioner may still raise the rent by the percentage allowed by the ordinance, the combined allowable increase and capital improvement pass-through shall not exceed 10% per year. The landlord shall comply with all other conditions listed by staff in the staff report. My findings will be issued within 20 days, and that's calendar days, and this item is concluded.
Thank you.
Thank you, Mr. Holling. All right, and finally, item 6, case RSQ 19-07874. Ms. Lewis, please proceed.
One moment, please.
Take your time, whenever you're ready.
Thank you.
You're welcome.
The item you mentioned is an interim rent stabilization ordinance petition for relief from moratorium. The petitioner is Laura Polito, who is the landlord, and the tenant, the respondents are the tenants at 744 through 746.5 South Woods Avenue, Los Angeles, California, 90022. The petition was filed on July 11, 2019. The petition for relief from moratorium is to request an increase in rents in excess of the allowable limit as established by the ordinance, as well as pass-through costs associated with the completed capital improvements at the property. So the petitioner is asking for both a temporary and a permanent rent increase. The property is located in the unincorporated area of East Los Angeles, is a residential dwelling on a property with 2 or more units, and was built in 1955. The petitioner returned the proof of service to DCBA on July 11, 2019, and we mailed out the initial notice of hearing on September 10, 2019. Key issues. The 4 rental units on the property are currently rented out for a reported total of $4,870 per month. And the petitioner is requesting a monthly increase of $205, which is a 4.21% increase, and a capital improvement pass-through. And where allowable, the petitioner has issued rent increases, and that's been for 2 of the 4 units per the interim rent stabilization ordinance. The following capital improvements were reported by the petitioner and substantiated by DCBA. There was an air conditioner improvement that was completed at the property, as well as the installation of vinyl plank flooring. DCBA received the following capital improvement expense-related documents from the petitioner. We received a paid invoice from NRG for $26,278.35. We also received a council check from Brian Torres for $3,890 and another council check from Hernandez Carpet Brothers for $96.80. So here I just want to outline how we arrived at any recommendations around the capital improvement that we mentioned. So like I said, there was an air conditioner project that was completed at the property, and the total amount paid was a little more than $26,000. And then for the flooring, there were 2 projects that were completed, and it was about $4,000 that was paid in total. For the pass-through, the total amount that's allowed to be passed through for the air conditioner is $17,518.90, and that is specific to 2 units because there were 3 units that received updated air conditioners or received completely new air conditioning, but one of the tenancies began after the project was completed. So just like in the last case, the tenant's rent should have already accounted for any costs associated with that. With the flooring, all of them, for the 3 remaining units, we are asking that the entire amount is allowed to be passed through. And that's because 2 of the units received new flooring, and one of the units that had already received an air conditioner prior to this going into effect, prior to this first air conditioner project being completed, had also received new flooring. So one of those is unique. The total pass-through amount per unit, and I'm sorry, there's an error in my presentation. For the air conditioner, we're calculating out that it's $8,759.45. And again, that's split between the 2 units. But for the flooring, we're calculating out that it is $296.67 and an additional $32.27. That's for 3 units. So for the air conditioner, we determined that there's an amortization period of 120 months, which is about $73 for the pass-through per month. And for the flooring, we determined that there is a recommended pass-through, an amortization period of 84 months. And so that's a little more than $15 for the monthly pass-through. So that totals to $88.82. However, the way in which that can be passed through to the tenants differs because of the amortization periods. So again, this is our calculation. We looked at the total applicable cost divided by the affected units, which in this case would be 2 units. In an amortization period of 120 months, which gives us a pass-through of $73. At 50%, we calculate that to be $36.50. For the flooring, again, we calculated it out for the total applicable cost of about $4,000, and that's divided out by 3 units in an amortization of 84 months, which gives us a monthly pass-through of $15.80. But at 50%, we calculate that out to be $7.91. So now I'm going to switch over to the permanent rent increase. So we also performed or attempted to perform a net operating income analysis, and we determined that the reported net operating income in 2018, which will be the base year, is about $41,218.70. And then in the petition year, we calculated a net operating income to be about $40,000, a little more than $40,000. The change in the CPI is 1.55% between the base year and the petition year. So that means there is a CPI inflated net operating income that should be at least $41,857.59. So DCBA calculated a reported annual, not monthly, net operating income of $40,595.33, which, as you can see, is less than the CPI inflated net operating income of $41,857.59. We calculate that the petition year net operating income is currently falling short of the CPI inflated net operating income by $1,262.26. However, at this time, DCBA is lacking sufficient documentation related to the cost of water in the base year, property insurance in the base year, and pest control in the base year in both the petition year. So for that reason, staff is recommending continuance of the interim rent stabilization ordinance petition for release case number, RSQ 1907874.
Thank you. As you're requesting, even though there isn't an individual here to speak, as you're requesting action on an item, I'm going to go ahead and open the public hearing. So are you optimistic that you'll be able to receive that additional information from the landlord?
At this time, yes. The landlord just didn't feel like she could get us back all of the documentation we needed in the time frame that was allowed at the time, so in time for this hearing. So we're asking that she can provide it to us in time for the next hearing by January 30th. And we've been clear about the expectations around that as well.
All right, thank you. I don't like bifurcating a case, even if it has 2 components. That can create a mess. So I will not be making a decision today on either aspect of the case.
Okay.
And you feel that January 30th as a continuance date is enough time to get the information from the applicant and to conduct your review and analysis as necessary?
Yes.
All right, thank you. And do you have anything else to add at this time?
Not at this time.
Did you have any questions or concerns, Mr. Trin?
Not at this time, Madam Hearing Officer. Thank you.
Thank you. Then to provide additional time to submit documentation by the petitioner and for staff to review the documentation, case RSQ 1907874 is continued to 30 January 2020. All right, thank you. And I do not have any other speaker cards. There is no one here for public comment. With that, then, the DCBA hearing officer is adjourned to 10 a.m. Monday, December 9th, 2020. Excuse me, Monday, December 9th, 2019. It'll be here before we know it. Thank you.